Hello, I'm John Trimbos, and this is program 3 of a 6-part series of webinars that I've recorded for Acuity. Sections 1 and 2 dealt with business writing skills in a general sort of way. This part 3 focuses on legal drafting. Now, if you've come straight into this without seeing programs 1 and 2, well, that's actually fine. That's okay, because the intent is going to be a bit different comparing general business writing skills and legal drafting skills. So if we are writing particularly to clients, or if we're writing proposals and things like that, then the idea is to summarize often quite complex legal ideas in clear, easy to understand language. Legal drafting, which I'm talking about now, is clearly a much more serious affair, because if you're drafting, say, a clause in a contract or some pleadings or anything like that, then you've got to make sure that the meaning is absolutely spot on, that it's totally nailed down, and that there is no room for misinterpretation whatsoever. And in fact, I'm going to start off with a little cautionary tale just to show you how easy it is for things to go wrong. So let me just open up this document here. This is a case, it's an American case, all about a missing comma, potentially, or an Oxford comma. And this was a dispute in the US state of Maine back in, I believe, July 2019. I read this. I was actually staying overnight at a hotel in Manchester, and this popped onto the Times website, so I could show it to them hot off the press. So this was a dispute between two parties. On the one hand, the employers were a company called Oakhurst Foods, and the other side were truck drivers. They were lorry drivers who were funded and represented by their union. And under the relevant provision, the employers did not have to pay overtime for any of these works. So here you go. No overtime payable for the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of agricultural produce, meat and fish products, and perishable foods. There you go. So that's exactly what it said. And this was a back overtime claim by the truck drivers, who said, we do not fall within this exemption. You have got to pay us overtime. And their argument was, they said, well, the top half of this sentence lists out all the things that you don't pay overtime for. And in line 2, it carries on: marketing, storing, packing for shipment or distribution. And we don't do any packing for anything whatsoever. We just drive the trucks around, but we don't do any of the packing for shipment or distribution whatsoever. And the employers said, no, hang on a minute, hang on, you're not reading that one properly. That is not one homogeneous item there, packing for shipment or distribution. It is two separate activities, two separate items: packing for shipment or distribution. And then the argument got very grammatical, because the employers said, look, it's just a matter of modern English writing style. In modern English, it is customary not to use an Oxford comma, so to put a comma before the and or the or at the end of the sentence. Just here, look, I'll insert the Oxford comma. There it goes. And if you insert an Oxford comma like that, and it goes packing for shipment, comma, or distribution of agricultural produce, and so on, then it does look more like two separate items rather than one. But of course, there was no comma there. So let's take it out again. There you go. No punctuation mark after the word shipment at all. And without the Oxford comma, I think you can actually read it both ways. It depends on what side of bed you get out of in the morning. Anyway, in July 2019, the union sued, and they won at first instance. And this was the article I found in the Times. There were lots of other articles all around the same time about this. And in fact, a few people, business contacts and friends and so on, they sent me web links. And certainly one of them said, hey, John, look, this is a case all about a missing comma. I bet you're getting really excited about this. And I emailed him back and I said, do you really think I'm the sort of sad person who gets excited about missing commas, and I got a one-word email back saying yes. So there you go. Actually, it is quite good fun. Anyway, the union sued and they won at first instance. And all the articles said, well, the employers will be appealing. And I'm not surprised, because this would have opened up the floodgates for lots of other back overtime claims. And this missing comma here was potentially worth 13 million US dollars, which was a seriously expensive piece of punctuation. Now, it actually went quiet for a year, and then in July 2020, it came back into the press because they settled out of court, and they settled out of court for $5 million. So it wasn't that expensive, but still pretty expensive. And as part of the settlement, they agreed a redraft. So you can see what I'm doing now. So all of these commas here were then upgraded to semicolon status. And semicolons, of course, are reckoned to be stronger than commas, maybe halfway in strength between a comma and a full stop. So here we go, storing semicolon, and then they inserted a semicolon after shipment. There you go, packing for shipment, semicolon, or distribution of agricultural produce, meat and fish products, and so on. And with a semicolon in there, that does split it up, and that pretty much does the job. But it was an expensive mistake, $5 million, expensive mistake. The other thing is, really, if you're going to legislate whether something is one item or two separate items, by far the best thing to do is to tabulate it. Semicolons in a list like that just about work, but you can forget to put them in. Whereas if you tabulate, if you strip out the list A, B, C, 1, 2, 3, then it does make it 100% clear whether that is one item or two separate items. And if you have seen programs 1 and 2 in this series, you will know that I'm a great fan of tabulation. So to really do a good belt and braces job on this, I would personally tabulate consistently. And also, I would split it up, because again, if you've seen programs 1 and 2, you will know that I'm an advocate of short, clear sentences and following the general mantra, expressing just one main idea per sentence. And that way I would split it up. So sentence 1 gives the overall scope for the clause. This clause governs work involving agricultural produce, meat and fish products, and perishable foods, but finish it there, say no more than that, full stop. And then in a separate sentence, deal with the overtime issue, the money issue. So this would have been the union's version. The employer is not liable to pay overtime for, and then we've tabulated the list, which goes to 8 items. Item 7G is storing, or last item, packing for shipment or distribution. And then this would have been the employer's version, which went to 9 items. Storing, H, packing for shipment, or separate item, number 9 there, distribution. And then with tabulation and line breaks and semicolon, then it really is 100% clear to the reader whether that is one item or two separate items, two separate activities. So good little cautionary tale there, actually. And we'll come back to that case in a minute for reasons that I will elaborate on. So that gives you a flavor of the kind of thing we're talking about and the need for absolute clarity and certainty. Now, there is a workbook that goes with this, and I'm just going to kind of skip through this booklet really as I chat to you, but by all means have a little read of the various notes and so on the various topics to get chapter and verse if you like. So part 1 of this booklet is all about interpretation rules, and it is important that you bear this in mind as we go into legal drafting mode rather than general business writing mode. Now, there are 9 rules here, look, 1.1 to 1.9, and these represent, if you like, the historical background, because the courts in this country were traditionally very, very reluctant to look outside the printed page for help with interpretation. So, for example, number 1, the document should be read as a whole and should almost always be interpreted solely by reference to the contents of the document. 1.6, example again, extrinsic evidence is rarely permitted to aid interpretation. That was very much the approach of the courts in this country until about the 1990s. So if there was, say, a contractual dispute, then the judge would read the document as a whole so as to read every clause in its context. But it was only under the very rarest of circumstances that the courts were inclined to look outside the printed page for help with interpretation. Now, that changed a lot in 1998 with this case, Investors' Compensation Scheme versus West Bromwich Building Society, where Lord Hoffman said in the leading judgment, almost all the old intellectual baggage of legal interpretation has been discarded. So what he said was these old interpretation rules are way past their sell-by date, and we need to move on and adopt a different approach from now on. And in paragraph 2, he talks about the commercial background, or the matrix of fact. And what he basically said is it is wrong to read any kind of document purely in isolation, just as a collection of sentences and paragraphs, because a legal agreement, for example, is a document that reflects a working relationship, and therefore you have to read it against the background of that relationship. Probably the key paragraph is paragraph 4 underneath, where he said, the meaning which a document would convey to a reasonable man is not the same thing as the meaning of its words. The meaning of words is a matter of dictionaries and grammars. The meaning of the document is what the parties using those words against the relevant background would reasonably be understood to mean. So again, you mustn't read anything in isolation. You've got to read it against its commercial background. And again, paragraph 5, the rule that words should be given their natural and ordinary meaning reflects the common sense proposition that we don't easily accept that people would have made linguistic mistakes and so on. But on the other hand, if one would nevertheless conclude from the background that something must have gone wrong with the language, the law doesn't require judges to attribute to the parties an intention which they plainly could not have had. So, it's focusing very much on the commercial intent of the parties, and therefore, if, for example, there are previous courses of dealings between the parties, then it would be entirely legitimate to look at those. You could look at how the parties themselves put the contract into practice day by day, week by week. If there were things like industry protocols or codes of conduct that govern how parties should act towards each other within that business sector, absolutely, yes, you could look at that as well. So it's a real change away from literal interpretation towards a much more inquisitorial approach. Let's try and understand the commercial intent of the parties. Now, on one level, that sounds quite good. The idea that judges are trying to be less ivory tower, a bit less purist and academic in their approach, which I suppose is true. On the other hand, what that means, though, is that if there is a little ambiguity in a document, just in a clause, and therefore you could read it one way or another in a certain context or not in a certain context, as the case may be, so there is some sort of ambiguity. In effect, I think this kind of inquisitorial doctrine gives the judge an enormously wide discretion to decide what the parties actually meant, and the discretion to overrule the natural meaning of a sentence in favor of something else. So I think it is potentially dangerous for drafters. Now, what I'm doing is I'm just reinstating the original wording here for this Oakhurst Foods case, because you see, I think the old literal approach was a little bit more predictable. So, for example, looking back at the Oakhurst Foods case, the argument, as you know, was, is packing for shipment or distribution one item or two separate items? Well, you see, under the old literal regime, I would have said that it would have gone in the employer's favor, because for that to be one activity, packing for shipment or distribution, there would have been an or after storing. The sentence would have gone storing or packing for shipment or distribution, but there was no or there. It just went storing, comma, packing for shipment or distribution. So regardless of background context or anything, if you're just interpreting that contract purely as a grammatical sentence, I would say packing for shipment and distribution are two separate items, and it would have gone in the employer's favor. Just my personal opinion, of course, but anyway. So the point that I'm making is you just got to be really, really careful. You've got to be super careful and make sure that everything in a legal document that you draft is so abundantly clear that there can be no possible room for misinterpretation. And that means taking the rules of plain English and really applying them much more strictly than we would do in day-to-day business writing. So nice short sentences, one main idea per sentence, ideally. Stick to the active voice. In sessions 1 and 2, I said you can use the odd bit of passive. Well, the passive can be dangerously vague, so I would say stay in the active voice all the time. Don't have any elegant variations of language. Use ruthlessly consistent vocabulary and so on. And if you apply all of these guidelines very strictly, then it keeps you on the straight and narrow, and it will give you a good, clear piece of drafting. Now, there are certain pitfalls that we need to avoid. So I'm going to now move on to a couple of negligence cases, just to identify some traps to avoid, and that will keep you on the straight and narrow. To be fair, there aren't that many negligence cases against law firms arising out of poor drafting. You get the odd one, and it does tend to be expensive when things go wrong. But yeah, most negligence cases against law firms seem to arise out of silly little errors, like, for example, missing time limits and things like that. But you get the odd one. So here we go. I've got two cases. The first one is very, very quick. It's a half-page little synopsis here. 2.1, Al Hussein Establishment versus Eton College. Just freeze the program now. Just have a little read through that synopsis, and then towards the bottom of the screen there is a question for you to consider, which is, what would you do to improve the contract terms? Obviously, it's easy to critique other people's drafting with the benefit of hindsight, but of course we do have the benefit of hindsight. So yeah, freeze me now, have a little read through, and then when you unfreeze me, I will tell you what happened. So, property development contract, two parties. Al Hussein Establishment was a property development company, and it was incorporated in some offshore jurisdiction for tax purposes, so that's why it had that funny name, Establishment. And then we have Eton College. So we have, world famous public school, our current Prime Minister's old school. And I didn't go to Eton myself or anything like it, but I'm guessing that Eton is a very well-endowed institution that is very wealthy and owns a lot of land. It certainly seems to own a lot of land around North London, where I live. And this was a case that involved a spare plot of land that the school had no use for, and they wanted to develop it for profit. And they entered into a development contract with Al Hussein, and it was very neat. The deal was that Al Hussein would be granted a very long head lease of the land. They would then build a commercial office block on the land. So imagine the kind of building you normally go to work in. They would then let out the business units to commercial tenants, and they would share the income streams. Al Hussein and Eton College would both get rental income from the development. So pretty neat deal, really. School provides the land, Al Hussein build the building upon the land. They both get lots of money. Now, Al Hussein applied to the local planning authority for planning permission, and the local planning authority was quite happy with everything. So they said yes, planning permission, building regulation consent, all of the necessary permissions and so on came through pretty quickly. And Al Hussein were about to start work on site, but they stopped. And they then refused to start work on site, and they withdrew from the development. They withdrew from the project. And the reason for that was that there was an economic recession. There was a pretty savage property crash. And Al Hussein's advisors basically told them to stop and to go away and invest their money elsewhere. So they did. And Eton were very upset about this. They sought their own advice from chartered surveyors. And their surveyors said, no, that's total rubbish. Of course, this is still a viable development, especially in such a nice central area and so on. So if that's what it was really an argument about the commercial viability of the project. Now, Eaton sued. Rather ambitiously, they sought specific performance, but obviously damages in the alternative. And the argument in court revolved around this phrase that I've reproduced in bold here, as soon as reasonably practicable. The agreement was that Al Hussein would apply for planning permission, etc., and as soon as reasonably practicable thereafter, they would commence, proceed with diligently, and complete the development. Now, in court, Al Hussein said, well, it wasn't reasonably practicable for us to build this wretched development because it was a commercial disaster just waiting to happen. We were being asked to invest thousands and thousands of pounds in development costs, construction costs, and so on, in return for little, if anything, at all. So it was a commercial disaster. So it wasn't reasonably practicable for us to proceed. And Eaton said, no, that's not what that means. And it was their lawyers who had drafted this. They said the word practicable in particular, you should read that as referring to practical physical matters that stop you working on land. Like, for example, extreme weather or flooding or landslip, or if a great big sinkhole opens up in the ground or something like that. You know, physical, practical stuff like that. Not wider issues of commercial viability. That's just an element of commercial risk, which they assumed. And yeah, you look at it and you think, actually, come to think of it, what the hell does that mean? It's not a defined term, so we're thrown back on the dictionary definition of reasonably practicable. And of course, the word reasonable is a subjective word. And you do see subjective words in contracts and things all the time. So what's reasonable, what's unreasonable, what's material, what's immaterial? We'll look at that one in a bit. Reasonably practicable, of course, flows on from reasonable. So yeah, just subjective words are inherently dangerous because that's what they are. They're subjective. They're open to different viewpoints. And yeah, no definition, nothing like that. So no particular help on the face of the contract, but obviously the court had to take a decision purely based on the facts. And on the facts, Eaton lost, and they were seriously upset. And they sued their lawyers in negligence, which is an unfortunate habit that some clients have. So, question for discussion, well, not so much discussion, more for you to think about is, what would you do to improve the contract terms? So when the country's economy was looking okay, there was agreement that this was a good, viable project, but all it took then was a change of circumstance, like a sudden recession, and suddenly the parties are not together at all, they're wide apart. So what would we do to improve the contract terms? Well, I think this is a two-part answer. So getting us most of the way there is a long stop date. And then you could still use this wording, actually. You could say that Al Hussein have to start work as soon as reasonably practicable after the grant of full planning permission. And in any event, on or before, and then you stick in a long stop date, which is 3, 6, 9 months down the line, whatever's appropriate, whatever you negotiate. And then at least you have the certainty that the work will start sooner or later. But I also think, I mean, obviously with these cases, you have to take an educated guess, but I think they were trying to dial in a bit of pragmatic flexibility to allow for the kinds of events that I mentioned, like extreme weather or flooding or landslip or something like that. And by far the best thing to do there is to define what constitutes a legitimate reason for suspending or postponing works. And the defined term, which I used many years ago, this was when I was a planning lawyer, and I was dragged into drafting and negotiating PFI construction contracts. And you don't have to use this defined term at all, but it's a good one, I think. Delay event, there you go. So you are allowed to suspend works or postpone works if there is a delay event, capital D, capital E. And then you look up delay event, and in the construction world, I gather that terms like delay events do tend to be drafted very narrowly to cover things like extreme weather and flooding and so on, rather than wider issues of commercial viability. So that's the idea. You are allowed to stop if there is a delay event as defined, but as soon as the delay event goes, as soon as the floodwaters recede and so on, then the timeline kicks in again. So I think it's two parts really, delay event and a long stop date. And first of all, it shows that these drafting issues are sometimes a little bit more complex than they appear at first sight. And I think they did take a slightly simplistic view in their drafting. So I think you need something, two-part, more thorough answer. And then there are two learning points from the Al Hussein case. The first one is don't leave time periods open-ended. So if you're going to specify a time for somebody to perform an obligation or within which they can exercise a right or an option or something like that, well then don't leave it open-ended. However you define time, you've got to be able to say for sure when does time start and when does time finish. And then the other learning point is beware subjective words like reasonable, material, anything like reasonably practicable that flows on from those words, because they are inherently dangerous. Now, I suppose the purest approach would be to say, don't ever use subjective words in legal documents. Pragmatically, we do, but what I would then say pragmatically is just ask yourself how expensive this is likely to be. So, for example, if you have provision for one side to pay the other's reasonable costs on a license to a sign or something like that, well, what the hell? Nobody's going to lose sleep in the commercial world over a few £100. However, build an office block. That's not a cheap little clause, is it? That's a really expensive clause. So in that case, relying on subjective wording is potentially very, very dangerous indeed. Right, that was quick and easy. That's just to get you started. The second case is rather longer. This is called Whitman Tools Limited versus Schuler AG. And I can't keep this on the page for you to look at because it's too long. It's actually, there you go, more like 2 pages long, with some rather horrible contract clauses. So you're going to have a look at your own copy of the notes. So yeah, stop the tape in a minute, have a little read through. Again, have a read through. When you unfreeze me, I will tell you what happened on the facts of the case. And then the question for discussion is not really a legalistic question. The question is, what did the drafter apparently forget, and how again can we improve on this? It's not a legalistic question. It's more like, what commercial reality did the drafter apparently forget? What commercial fact of life did the drafter apparently forget? And again, how with hindsight can we deal with this? There we go. So freeze the program, have a read through. It'll take you a few minutes with those horrible clauses. When you're ready and you've had a chance to think about the question, start the program again. And again, I will tell you what happens on the facts of the case. So, welcome back. Just going to have a little swig of tea. This one is a bit of a handful. So we have two parties here again, Whitman Tools Limited versus Schuler AG. Whitman Tools Limited was a British company that was dissolved many years ago. Schuler AG still exists, or as of the date of recording, June 2022, it's still in existence. I saw a reference to Schuler a couple of years ago on the front page of the Financial Times, and I thought, wow, they're still going after all these years, and they still are. They're a German manufacturing company. Their background is in making equipment, heavy equipment for mainly the motor industry, so things like panel presses and conveyor belts and paint shops and things. These days, they are very much into IT as well. So if, for example, you have a touchscreen sat-nav in your car, then it may well be a Schuler product, especially if you drive a German car, of course, like a BMW or a Mercedes or an Audi or something. Now, this was an agency and distribution agreement, and it involved Whitman Tools as sole agents selling panel presses and other Schuler products in the UK. And towards the bottom of page 5 there, we have an obligations clause, which is headed promotion by sales. And sales was a defined term. It meant Wickman Tools Limited and its army of self-employed salespeople. And it said that sales will use its best endeavors to promote and extend the sale of Schuler products in the territory, which was basically the UK mainland. And then underneath that, clause 7b, sales shall send its representatives to visit the 6 firms whose names are listed in the schedule hereto, at least once in every week for the purpose of soliciting orders for panel presses. And then if you couldn't make that client care meeting, then you had to find a substitute and so on. And then underneath we have a clause 12b. Sales undertakes at its expense to look after Schuler's interests carefully and will visit Schuler customers regularly and so on. So that gives you a flavor of the kinds of obligations that Wickman Tools are under. Now, what happened in practice was that Wickman Tools were absolutely useless. They were underfunded, disorganized, poorly managed. I get the impression they probably bit off more than they could chew with this contract, but they're a bit of a shower, and they had extreme difficulty in holding on to staff. Big staff turnover, lots of missed appointments, and generally shambolic behavior. And Schuler became very disillusioned very quickly with their new UK business partners. Now, clause 11 underneath here is where the whole thing goes pear-shaped. So clause 11 you will have seen is, well, it's headed duration of agreements, but actually it contains a lot more than that, because it also contains the possibility of early termination and also breach of contract, which is a little bit surprising really, because breach of contract is really quite a major topic. And I would have said myself that a major topic like that really deserves its own separate clause. You don't just mash it up into something else, but that's what they did here for some reason. Now, you will also have seen that it's a very long sentence, and long sentences are often the enemy of clarity. Sometimes you get away with it, like in this case, I think you just about get away with it, because all you have to do is, whenever you see a connecting phrase like then or provided that or something like that, just pretend it's a full stop, and then you can see that it does kind of make sense, but it's not well drafted. And it's not so much the standard of the drafting, although that's not great. It's more the content that turns out to be not good enough. The content is just not fit for purpose. Anyway, taking it apart bit by bit, the first part gives us a contract term of just over 4.5 years. So the contract runs from the 1st of May 63 to the very end of 1967. And thereafter, so possibly for longer than that, unless and until determined by either party upon giving to the other not less than 12 months' notice in writing to that effect, expiring on the said December 31, 1967, or any subsequent anniversary thereof. And I'm going to pause there at the end of line 5. So, yeah, basic contract term, but it could have carried on for longer and thereafter if it had been a successful arrangement. On a year-by-year rolling basis. But if the contract had come to its natural end, then one party would have served 12 months' notice to terminate at the end of 1966. 12 months' notice terminates the contract at the end of 1967. Right, now we've got to the end of line 5. So provided that, I mean, basically just pretend that's a full stop. And here we have a new item here. Schuler or sales may by notice in writing to the other determine this agreement forthwith, if the other shall have committed a material breach of its obligations hereunder, and shall have failed to remedy the same within 60 days. So if one party thinks the other's in breach, you serve this clause 11a notice. You've got 60 days to remedy the breach, and if you do, then we're good. If you don't, then we can determine the contract. We can bring the contract to an end. And what happened was that Schuler served quite a few of these clause 11a notices on Wickman Tools in the first year of the contract, and Wickman Tools would scramble the troops, recruit new staff, get them sent out to sell panel presses and things, their performance would go up for a little while and then it would start to decline again. And then eventually Schuler just lost patience and they sent a letter to Wigmantour's head office saying essentially you're sacked, or in the words of Lord Sugar, you're fired. I mean, I'm sure the letter itself would have been a lot more elaborate than that. I bet it was a solicitor's letter saying something like, our clients Schuler have resolved to repudiate this contract on the basis of your persistent and serious breach, etc., etc. But it was basically you're fired. Now, Wigmantour's wrote back and they said you can't do that. If you think that we're in breach, which we dispute, by the way, then your obligation, Schuler, is to serve a clause 11A notice like that. There is no provision in the contract that just allows you to terminate the contract or anything like that. The argument then, well, they ended up in court. The whole relationship broke down. And the argument in court revolved around the introductory wording to clause 7B. There you go. It shall be a condition of this agreement that sales will go out once a week to sell panel presses and so on. And you'll probably remember from your law of contract days all about conditions and warranties and things. So on the face of it, a warranty is a lower level contract clause. And if you breach a warranty, then the other side can only ever claim damages as compensation. But a condition is a more fundamental term that goes to the root or the heart of the contract. And if you breach a condition, then the other side can repudiate the contract and bring it to an end. And Schuler, in this case, they said, well, it was our lawyers who had drafted this, and we had this wording inserted here in 7B specifically. It shall be a condition of this agreement that sales go out once a week to sell panel presses and so on. And this is supposed to flag up to the reader that this is a really important clause. It's a fundamental clause to us. And if you breach this, then we should be allowed to treat it as a condition in that sense and repudiate the contract. And Wigmantour said, no, that was not the agreement. We never agreed to that. Our understanding was that clause 11A there was to be the sole mechanism for dealing with breaches. That was the regime for dealing with breaches of contract. There was no carve out for 7B. There was no suggestion that 7B would be exempt from 11A or anything like that. And there's, as far as we're concerned, that introductory wording to 7B, it shall be a condition. That's just a bit of legalese that kind of crept in. But we never agreed that that should be a condition in that sense at all. And the thing is, the courts in this country have always had an overriding discretion to decide whether something really is a condition or not. So just labeling it conditional, saying it shall be a condition of this agreement, that is not enough. It never has been. And there was no carve out from 11A there. There was no cross-referencing or anything helpful like that. So a bit of a contradiction on the face of it. And also that quote there from Lord Reed does suggest that the whole thing was probably a bit of a muddle anyway. So the court again had to make a ruling on the facts. And on the facts, Schuler lost. And of course, they were bitterly upset and hit their UK legal advisors with a negligence suit. So the question is, what commercial reality did the drafter apparently forget, and how, again, with hindsight, can we improve on this? This is really, in classes, when I have a small group of people, I'm often met with a wall of silence on this one. But just to give you a steer, this is really all about the last 3.5 lines of clause 11A there, and it's basically just not good enough. The content is basically not good enough. It is not fit for purpose. So if I am faced with a wall of silence, what I then do is I ask a straight yes or no question. And the question is, are all breaches of contract the same? And then everybody goes, well, no, they're not. You can have more or less serious breaches of contract. And in an agreement like this, imagine one side being a few days late sending a monthly payment to the other. Well, what the hell, pay interest on the outstanding sum. But failure to make scheduled client care visits and things, that's a much more serious breach, isn't it? And then your common sense should really say to you, well, more serious breaches should have more serious consequences. And yeah, in this case, they took a one-size-fits-all approach. Any breach of any provision in the contract should have exactly the same remedy, which is the 60 days and so on. And it's just too inflexible. You need to accommodate different levels of breach. Now, in the PFI road construction stuff that I used to be involved with, we actually had the defined terms major breach and minor breach. So what you do is you categorize each potential breach according to seriousness. So for the sake of argument, if you breach obligations 1, 2, 3, 4, 5, 6, that constitutes a minor breach, capital M, capital B. What do you get for that? Damages. But if you breach clause 7b, that constitutes a major breach. And what can you do then? Well, you can determine the contract, bring it to an end. And what I think would have suited them would have, in this case, would have been maybe 3 levels. So totally unserious minor breach, bit more serious material breach. So material breach, you have your 60 days to remedy the breach. And if you don't, then we can determine the contract. And then major breach, we can determine straight away without any remedy period whatsoever. And that really would be apocalyptic stuff like fraud or gross negligence or something like that. So yeah, I think 3 levels: minor breach, material breach, serious major breach. And then I've also seen more complex contracts that might say, for example, if you have more than 6 minor breaches in a calendar year, then that constitutes a material breach. And if you have more than 3 material breaches in a calendar year, then that constitutes a major breach. And that then deals with kind of persistent breaches. You know, the idea is you can accumulate so many breaches, a bit like getting penalty points on your driving license, but then you hit a certain threshold of seriousness, and then suddenly you're facing an endorsement or termination of the contract. My other suspicion about this case is, I mean, it doesn't look like a standard form precedent. It looks very much to me like a kind of one-off bespoke agreement that was drafted from blank sheet beginnings. And I bet the drafter got stuck into the word-for-word drafting a little bit too quickly. And that's the thing, is if you go too detailed too quickly, if you start dictating this contract is made the blank day of blank 2022 and so on, and you kind of build it up from there, then very often you can get overwhelmed with the detail and you just don't see the wood for the trees, and you can miss these commercial points, not necessarily legal points, but commercial points. So if you are having to do something from blank sheet beginnings rather than a precedent, for example, then I would seriously suggest that you do it in 2 stages. Stage 1 is the macro level, which is where you basically draw up a skeleton outline of the document. So maybe just write headings and subheadings: date, parties, recitals, duration, money, force majeure, you know, just, but no more than the clause headings, and build up a skeleton outline, if you like. And once you've done that, and maybe chest it through with the clients, that's the best way to spot these big issues. You know, what breaches might there be? What remedies should we have? What sort of ADR provision should we incorporate? You know, big picture stuff like that. Get that sorted, then do the word-for-word drafting afterwards. And if you do that, then it'll virtually write itself, because the hard intellectual work is the actual structuring and deciding what clauses do we need to make for a workable contract. The word-for-word drafting is then taking those ideas and just fleshing them out and putting them into sentences. But in many ways, it's the structuring that is the hard work. Now, in the following program, number 4, we're going to do a little exercise around that just to illustrate how that works. But you know, do bear that in mind. I do appreciate that for most of the time you will be drafting using a precedent. I'm sure that's the case at least 9 times out of 10, but every now and again you will have to do something bespoke, and that's where, yeah, that's where you do have to do something that requires quite a lot of intellectual effort like that. Now, let's assume that we are working on some hypothetical contract. We've decided that the big picture is okay, that the the whole shape and structure of the contract looks good and fit for purpose. What you then do is you then either do the first draft yourself, or the other side do the first draft. They send it through to you, and you then have to assess the language to see whether it is clear and watertight and generally fit for purpose. Now 3.1 on the screen there is not clear, watertight or fit for purpose at all. It's an absolute disaster. It's almost a masterclass in how not to draft a contract clause. It's one of these clauses that has leaked out into the public domain, and it is, the story that goes with this is that it was drafted by a lawyer in a Magic Circle law firm who received the sack shortly afterwards. I have no way of verifying any of this information whatsoever, but that's the story that I've always heard. And it's not terribly good, really. I mean, again, it's a very long sentence, and in my humble opinion, it really should be 3 separate sentences. And of a more detailed word-for-word nature, I reckon there are 10 really quite serious issues, really quite serious problems within these 5 and a bit lines. So what I'd like you to do now is to have a little read through that. Make a note of anything that you think looks wrong or subjective or vague or anything like that. There is a typo in here. And there is also, in my opinion, a totally inappropriate, elegant variation of language, which we should avoid in legal drafting. So, a bit of a smorgasbord of drafting howlers, really. So, stop the program now, freeze me once more, and then when you resume, then I'll go through each line and identify all of the issues, and you can see if you agree with me. Okay. Doubtless you did not have an enormous amount of fun doing that. Pretty grueling stuff, but the kind of scrutiny that contract clauses, for example, do require. So there is a whole load of legalese in here as well. So that doesn't help, like the first half dozen words of line 1. But of a more serious kind of nature, well, let's go through it line by line. The clause itself looks pretty bog standard to me. I mean, just using a bit of educated guesswork, because it's talking about a 10-year period, I reckon that this was a new building and that the landlord had a usual 10-year new buildings guarantee from the building contractor. So the scheme was that if a material defect should occur within the 10-year guarantee period, tenant could serve notice on the landlord, and then the landlord should serve notice on the building contractor to trigger the guarantee, and then the building contractor would have to come back and remedy the defects. That's what I think it's trying to say, but boy, does it take its time doing so. Anyway, of a more detailed nature, right, issue number 1 is on line 1, tenant has been typed with a small t, and I'm sure this is a typo. And if it had ever gone to court, chances are the judge would probably have said, oh, it's a typo. But you never know with judges, do you? You know, some eccentric judge saying, oh, is it not the tenant? Therefore, is it some other tenant? Is it an assigned tenant or a subtenant or something? No, it's not, it's the tenant. So that should be capitalized on line 1. Then issue number 2 is vagueness, because it then goes and subject to the clauses hereinafter contained. Yeah, what clauses exactly? The whole lot? Or that sounds totally inappropriate. What I think it's trying to do is I think it's actually trying to refer to 2 issues on line 1, because it says at the request and cost of the tenant. So 2 issues: request of the tenant has to serve a request, or I would say serve notice on the landlord, and cost of the tenant, well, commercial tenants typically pay a quarterly service charge as well as their commercial rent. So that's what I think it's trying to do. I think it's attempting to cross-refer to the notice clause and the service charge clause and saying this is subject to the tenant complying with these clauses. But it's vague. You know, if it should be specific, it should say this clause is subject to these clauses. So if you see that kind of specific cross-referencing, that's probably a thoughtful drafter thinking carefully what's subject to what. If you see this kind of vagueness, well, just assume you're dealing with a lazy drafter. That's taken us on to line 2. On line 2, I'm sure you spotted this, but material defects is not defined. So again, we're thrown onto the dictionary definition of material, which means not desperately serious, but more than trivial. And I ran all of these issues past a senior property lawyer recently, and she agreed with all of these points. And she said that if you define material defects, it establishes a much greater level of certainty and cuts down the prospect of commercial dispute between the parties. So material defects, if it has capital M, capital D, what you can do is create a list of items which constitute material defects, like subsidence, damp, rotting timbers, things like that, and then you can import a pretty decent degree of certainty into what is a material defect. So I would capitalize and define that. So that's 3 points. Moving on to line 4, which takes a lot of time to say not very much. First of all, stylistically, it's passive voice. So it talks about material defects being noted to the landlord by the tenant in the passive voice and are notified to the landlord. So let's say it again. But that's me being facetious, by the way. But of a more serious kind of nature, though, I reckon that this is trying to say the same thing as line 1, request of the tenant, because in line 1 it talks about a request of the tenant to the landlord. In line 3 it talks about now a notification to the landlord by the tenant. Because it's different vocabulary, that immediately raises the question, are they 2 separate processes? Is there a request process and then a notification process? And I don't think there is, actually. I think it's one and the same thing. I think it's serving notice on the landlord. So really, that's my more serious point, is it suggests there might be 2 processes, whereas I think there's just one. If there's a material defect, tenant serves notice on the landlord. Now, towards the end of line 3, always watch out for the word from, so and indeed the word within. So it's talking about serving notice on the landlord within 10 years from, and you don't have to say the date of, 10 years from 22nd January 1989. That means that certainly in England and Wales and Scotland and both parts of Ireland, time starts running on the 23rd of January, not the 22nd. Most clients wouldn't appreciate that, non-lawyer clients certainly. And you can change it. You could say 10 years from and including the 22nd, in which case it starts on the 22nd, not the 23rd. The alternative way of expressing time is to focus not on the start of the 10-year period, but on the end. And I will show you that in my redraft. But do watch out for the word from, because from the 22nd means time starts on the 23rd. And so if the client had to work out the last day of a time period, then there's a strong chance they might get it wrong. Then we have a couple of vaguenesses. So enforce such rights, if any. I mean, come on, either he has rights or he doesn't. So that needs to be much more specific, like the landlord should serve notice on the building contractor under the relevant part of his building contract. And then the number of people who have queried what is it, as it may have. I mean, I think it can logically only be the landlord, but it's a legitimate point. If you have 2 gender neutral parties, landlord, tenant, buyer, seller, and so on, and then you say it, well, it could be one or the other. So much better to specify the landlord. Then, so that I believe is 7 comments down, 3 to go. I would capitalize building contractor. I'm not sure it was even necessary to mention the subcontractors, but if I'm missing something there, then that could be subsumed into the definition. Capital B building, capital C contractor. My thinking is really 10 years is a long time. A lot of paperwork can go missing. Lease could be assigned many times over. The landlord could sell his reversion in year 9 or 10. You might suddenly realize there's no record anywhere of the identity of the building contractor. So ideally, building contractor would then be defined and then listed in the definitions clause. You'd find the name for company and a company registration number. And ideally, we would then have a copy of the 10-year new buildings guarantee in an annex or a schedule to our own lease as well. So then within our own legal document, we have the identity of the building contractor and the nature of the building contractor's 10-year obligation. 8 down, 2 to go, 4 on behalf of the tenant, completely unnecessary. If the landlord is taking enforcement action to remedy defects, well, he's protecting his own estate, he's protecting his own investments, so we don't need to do anything for and on behalf of the tenant. And then we have our least favorite word, as are reasonable in all of the circumstances, right at the end of the sentence. And you could write that off as a bit of fluff as well, but I think it's potentially dangerous. I think you could read that as providing the landlord with a discretion to decide whether something really is, whether it's reasonable to make a claim against the building contractor or not. And if I were the tenant paying my commercial rent and my quarterly service charge, I'd be really unhappy about that. I would seriously be unhappy about that, and I wouldn't want him to have that kind of discretion at all. So generally not very good, actually, is it? Or pretty diabolical. Now, obviously there are many ways you can express things, but I'm just going to finish off this program now by doing my own suggested redraft. And as I have suggested, I would do it in 3 sentences, because very often actually it's within these long sentences, it's often in the connecting wording that glues one idea to another. That's often where you get vaguenesses and ambiguities. So chopping it up into short, clear sentences gets us off to a really good start. So you could say if there is a material defect in the building, or you could say if a material defect occurs in the building or the property, or whatever you want to call it, follow house style. So, or if material defect arises in the property, but here we go. If material defect occurs in the property, the tenant, now bear in mind this is a right, not an obligation, so may serve notice on the landlord. Now, within this 10-year period, you could do within 10 years from and including 23 January 1989, or the alternative is just to jump to the end of the 10-year period, and they're both legitimate. So I'm just going to go with that option because I think it's a bit neater, but I don't really mind. So the tenant may serve notice on the landlord on or before 23 January 1999. So that's, yeah, that's one sentence that simply gives the tenant's right. Sentence 2 then is then, well, the exercise of the tenant's right triggers the landlord's obligation. So then the landlord, and then there are 2 different verbs people tend to use for obligations. So either shall or must. Shall is more traditional, but reckoned to be more elegant. Must is more modern, but some people think it sounds harsh and brutal, but shall and will mean must. So the landlord shall or must within. Now, there's also, it's kind of missing the landlord's response time. So it's actually even worse than it looks. So what we'll say is the landlord shall or must within 5 working days or business days of receipt, whatever defined term you use. Now we use consistent language. So serve notice, again, you can see consistent language, serve notice on the capitalized building contractor. And then there's a whole load of stuff I don't have, so I'm just going to have to use an ellipsis. So under clause ... but that would be under the relevant clause of his building contract. All the details that go with that. And then finally, we have the cross-reference. So this clause is subject to, and then we put in the 2 specific clause numbers. So the service charge clause, whatever that is, and the notice clause. So this clause is subject to clauses 41 and 42, whatever they are. And you can see that is so much neater and clearer as well. And then we've used defined terms to deal with the materiality of the defects and so on. So same principles as the business writing sessions 1 and 2, nice short sentences, use clear language and so on. But over and above that, use ruthlessly consistent language, serve notice, and so on. And then we've also used defined terms to deal with particular issues. So you can see how this builds on the lessons from sessions 1 and 2, but much more strictly to achieve clarity within legal drafting. And that is where I'm going to pause now, and I'm sure after that you have had more than enough. So I will let you recover from that process, and I will see you again in session 4. So if you are drafting anything in the meantime, good luck with that, and I shall look forward to seeing you again. Bye.